You may have heard this before, only not in Quebec. This is about a class action lawsuit here against the Quebec Major Junior Hockey League. It's being launched by one person who played in that league, who's now 45 years old, by the way, back in the day. And it's all about hazing. When I say you've probably heard this story before, it's because this same sort of story already has gone through Ontario, where they sought to do something with it, launch a class action. It did not work there. Mm-hmm. What's going to happen here, and does it have a chance of getting through here even if it didn't go through in Ontario? David STOLOW is a lawyer at Kandestin, a Montreal law firm, and he is representing the plaintiff in this case. He's on the line right now. David, thanks for being here.
My pleasure, Aaron.
Let's talk a little bit about, first of all, what this suit is about, who does it represent, and how much is being sought here?
Sure. So the suit is on behalf of all players who have played in the Quebec Major Junior Hockey League since the league was formed in 1969, and for all players who were minor persons and who suffered any form of abuse, whether that be sexual, physical, or psychological abuse, while they were playing in the league.
All right, so I just want to mention, you're covering roughly, if I'm doing the math right here, like 40 plus years of players who've been in Quebec Major Junior Hockey League at any one time. They don't have to have been victims, they just have to have been playing in the league?
No, they have to have been victims of a form of abuse.
Okay.
So it is not every player who played in the league. It is those persons who were victims of abuse.
Hold on. And I want to just clarify again, if that's the case, would they have had at some point during that time to file a motion claiming they had suffered a hazing ritual?
Yeah, how do you prove that?
How do you know who they are?
So the answer to that is absolutely not.
Okay.
Any person who played and who has suffered abuse, they automatically form part of the class action that we have filed. So nobody has to take any steps at this stage. Nobody at this stage has to have made, have had to make claims of abuse in the past. In many cases, these types of situations are not disclosed for various reasons until much later.
Right.
And so all of those people are still part of our class action.
Okay.
Could someone, and I'm sorry to ask such a specific question, but I'm just curious to understand who would feel comfortable coming forward. If you were witness to this abuse, could that in itself be deemed abuse? Because it could have a detrimental psychological effect on you.
Yeah. Right now, it's a great question, and I thank you for asking it. Right now, it's the class is defined as those persons who have suffered abuse. In terms of the question of who would come forward, one thing that's important to note is that right now, Mr. Latulippe is the proposed class representative. He is, if you will, the face of the class action. People who communicate with us, former players, current players, any of their communications with us are kept in the strictest of confidence. So no one's name or no one's situation will be disclosed publicly at this stage. And so we want to encourage people and let them know that they can communicate with us, and everything they say will be kept strictly confidential.
Okay. So we're talking about a potential $15 million class action lawsuit. I'm curious, given the fact that an Ontario judge recently did not allow a case to move forward, how confident are you that it won't be the same outcome here?
Yeah, sure. So just a quick point. So what we're seeking in the class action, you're right that it's a claim for punitive damages of $15 million, which is being claimed on behalf of the entire class. But there is also other forms of damages for moral damages and financial damages that each class member will also be entitled to claim. So, for example, in Mr. Latulippe's case, we are seeking $400,000 in what we call moral damages and $250,000 in financial damages. Later in the process, if the class action is authorized and this goes to trial, there will be the opportunity for other class members to claim the specific damages that they have suffered. So it's certainly larger than the $15 million. in terms of what has transpired in Ontario, at first blush, people will look at it and say, well, both, class actions seem to be about the same type of conduct, which is true, but there are some pretty fundamental differences in terms of what transpired in Ontario, both in terms of the scope of the class action that was sought there, which was all three major junior hockey leagues, and it involved 70 teams, and it involved a sort of theory of collective liability that the judge in Ontario had difficulty with, and didn't see that as a class action that was manageable. And there are also differences between Ontario and Quebec in terms of the criteria that have to be met in order for a class action to move forward. So we don't have any concerns based on the fact that the class action was not authorized in Ontario. It's a completely separate issue as far as we're concerned.
David, fair to say, as you mentioned that, I think to myself, we're kind of the king of class action lawsuits here in the province of Quebec. They tend to move here before they might anywhere else.
Well, I mean, in the past, Quebec, has had that reputation. I think it's changing. We have criteria in Quebec that are, as I mentioned, different than what they are in Ontario. For example, in Ontario, you need one player, if you will, or representative for each team that may be involved, whereas here in Quebec, we don't require that. So, for example, the fact that Mr. Latulippe did not play for all 18 teams in the Quebec Major Junior Hockey League doesn't prevent him from acting as a representative on behalf of the class. Right. So there are still, obviously, authorization criteria that apply here in Quebec. But what's important for people to understand is that at the authorization stage, where you're effectively saying to the court, will you give us permission to move forward with this case as a class action, there's no burden of proof in terms of the merits of the case.
Right.
So you don't have to prove all of your allegations. What you have to do is establish that if you take the facts as they are alleged to be true, is there a defendable case? And if so, then the case should be allowed to move forward as a class action.
Last question, because some people might wonder, in the case of your particular lead plaintiff here, if you will, Karl Latulippe, why would he not have simply gone to you and said, look, I played and I was, involved in this hazing. I was a victim here, and just gone ahead on his own and sued? Why would that not have happened?
It didn't happen in the case of Mr. Latulippe because he has a very profound sense of responsibility. And I say that on two levels. First is with respect to the fact that he knows that he is not the only one that this happened to. He witnessed things. He's been certainly following what's been going on for the past couple of years and the stories that have been reported more recently. So he knows that there are others in his situation who have suffered horrendous forms of abuse, and he feels a very strong sense of responsibility to those people. He's shown tremendous courage in terms of coming forward and speaking publicly about his case. The second form of responsibility is on a going forward basis, and the sense that this has to stop. There has to be a change in a culture that would allow and tolerate these things to happen. And so the class action is a vehicle that allows Mr. Latulippe to not only assert his rights, but to assert on behalf of other class members their rights. And that's why the decision was made to seek permission to file a class action.
David, I want to thank you for the time. We appreciate it.
It's my pleasure. Thank you.
David Stolow, lawyer at Cooper Kandestin, representing the lead plaintiff here in a suit against the Quebec Major Junior Hockey League. And again, this is anybody who played between 1994, or at least, I guess, going back to 1969, up until that point. And we'll see what happens. They see if they get class action status or not.